Then 40 minutes of me catching you red-handed.
Red-handed? There was one redaction out
Where
of
he's
over
listed as a co-conspirator.
4,700, and we invited you
Switch,
in.
gentlemen.
This guy has Trump derangement syndrome.
40 minutes before the moment that would ignite the room, before the headlines, before the clip began circulating across every platform that matters in American politics, Thomas Massie already knew exactly what he was going to say. He was not improvising. He was not reacting emotionally, and he was not walking into that hearing with vague suspicions or partisan talking points. He had spent 2 days inside a secure Department of Justice reading room reviewing the unredacted Epstein Files line by line, page by page, knowing that what Congress had ordered released to the public did not match what he was reading behind closed doors. What he found was not a rumor, not an interpretation, not a theory, but a specific redaction in a specific FBI document that could not be justified by any legitimate reading of the law he himself had helped write. And when you understand that part first, you understand why what happened next did not look like theater, but like a confrontation built on documentation. The House Judiciary Committee oversight hearing on February 11, 2026, was already tense long before Massie's turn arrived. Survivors of Jeffrey Epstein's abuse were seated in the gallery, dressed in white, silent but unmistakably present, their presence transforming what might otherwise have been another procedural oversight session into something morally heavier. Cameras were mounted at every angle, red lights blinking, reporters filling the back rows with laptops open, waiting for something that would cut through the noise of partisan repetition. Attorney General Pam Bondi sat at the witness table, posture composed, expression measured, flanked by staff members who had spent weeks preparing her for predictable attacks. Democrats had already accused her department of shielding powerful men while exposing victims, and Republicans up to that point had largely defended the Department of Justice's process as an imperfect but sincere effort at transparency. The law at the center of this confrontation had been passed only months earlier. In November 2025, Thomas Massie and Ro Khanna introduced the Epstein Files Transparency Act, a bipartisan bill requiring the Department of Justice to release all unredacted records related to Jeffrey Epstein without carving out safe havens for wealthy associates or politically connected figures. The bill passed Congress and was signed into law, carrying with it a deadline that the DOJ was legally bound to meet. When the deadline arrived, the department released millions of pages, but thousands of redactions remained scattered throughout documents that were supposed to reflect full transparency. Some of those redactions exposed victims' information while obscuring the names of powerful men, a discrepancy that did not go unnoticed. Massie had warned publicly that the redactions made no sense, that the law did not authorize selective concealment designed to protect reputation over truth. He and Khanna had openly discussed contempt proceedings if the Department of Justice failed to comply fully, signaling that this was not going to be another performative dispute resolved with a press statement. The unredacted files Massie reviewed in the secure room revealed something precise and undeniable. In one FBI document, an individual was flagged internally as a potential co-conspirator in Epstein's criminal network. In the public version released by the DOJ under Bondi's authority, that same name was blacked out. That was not a question of privacy for a victim or the protection of a minor. It was the concealment of a billionaire's name in a co-conspirator context. When the hearing began, Democrats took the first swings. Representative Jamie Raskin accused the Department of Justice of running what he described as a massive Epstein cover-up, arguing that transparency had been promised but not delivered. Representative Pramila Jayapal demanded that Bondi turn around and apologize directly to the survivors seated behind her, an emotional appeal designed to underscore the moral gravity of the moment. Bondi declined, insisting that the department had balanced transparency with legal obligations and ongoing investigative considerations. She pivoted repeatedly to criticizing the prior administration and Merrick Garland, framing the controversy as a continuation of inherited complications rather than a failure of current leadership. That rhythm was familiar, almost predictable, And until Massie spoke, the hearing followed the well-worn script of Washington oversight theater. Democrats accused, Bondi deflected, and Republicans largely framed the department's actions as reasonable under complex legal constraints. The temperature in the room was high, but it was not yet combustible. Massie sat quietly, papers organized, waiting not for a moment of outrage, but for his allotted time. Those who have watched him operate know that when he asks a narrow question, he already knows the answer, and he is not fishing for headlines, but building a record. When his turn finally arrived, there was no raised voice, no rhetorical flourish, no attempt to match the emotional tone set earlier. He began calmly, almost conversationally, addressing Attorney General Pam Bondi with a directness that immediately altered the energy in the room. He stated that he had spent the week reviewing the unredacted Epstein Files and had identified a discrepancy in a specific FBI document listing individuals connected to the investigation. He held up a printed copy, highlighted, not for spectacle but for precision, signaling that what he was about to ask was grounded in the record and not in rumor. Then he asked the question that shifted the atmosphere from partisan exchange to documented confrontation. In that FBI document, he explained, a name appeared flagged by investigators as a potential co-conspirator in the Epstein case. Yet in the version released publicly by the Department of Justice, that same name had been redacted. He did not accuse, he did not editorialize, he did not speculate about motive. He asked simply why the name of a potential co-conspirator had been concealed from the American people under a law that required transparency. The silence that followed was not the routine pause before an answer, but the tightening stillness of a room that understands something significant is about to unfold. Bondi shifted slightly, glanced toward her staff, and began to recite the standard defense about balancing transparency with privacy and investigative equities. Massie did not allow the answer to float into abstraction. He clarified that he was not asking about process in general, but about one specific redaction in one specific document. He stated clearly that the individual in question was not a victim seeking anonymity, and not a minor whose identity required protection. The person had been flagged by the FBI internally as a potential co-conspirator, and that fact alone made the redaction legally and morally consequential. His tone remained steady, but the edge sharpened as he repeated the question, focusing the hearing like a lens narrowing on a single point of light. Then he said the name aloud for the record. Les Wexner, a billionaire, former CEO of Victoria's Secret, a man whose documented relationship with Jeffrey Epstein had long raised public questions, including the extraordinary fact that he had granted Epstein power of attorney over significant financial matters. Wexner's name appeared thousands of times across the Epstein Files, but in this particular document, in the context of potential co-conspirator identification, it had been blacked out in the public release. Massie did not shout the name, he stated it plainly, and that simplicity made it impossible to dismiss as grandstanding. Bondi attempted to recover by noting that Wexner's name appeared thousands of times in the files that had been released, implying that no effort had been made to conceal his connection broadly. Massie cut in gently but firmly, acknowledging that fact while returning to the narrower issue. The question was not whether Wexner's name appeared elsewhere, it was why it had been specifically redacted in the context of potential co-conspirator designation. The distinction mattered, and everyone in the room understood that it mattered because it was the difference between general association and investigatory implication. The tension at that point was no longer partisan. It was procedural and factual. Staffers behind Bondi began typing, searching, conferring in whispers, while reporters leaned forward. The question was no longer whether the DOJ had released documents, but whether it had selectively shielded a powerful figure in a legally sensitive context. Massie was not finished, but even before the next escalation, the structure of the confrontation had been set. A Republican congressman who co-authored the transparency law was asking a Republican attorney general why her department had concealed a name that federal investigators had identified internally as potentially complicit. And that is where this first phase ends. not with resolution, but with the precise moment before the revelation that would transform a pointed question into an accusation supported by timing and documentation. Massie had asked why the name was redacted, and Bondi had offered generalities. What neither the room nor the viewing public yet knew was that the timeline itself was about to become evidence, and that within minutes, the narrative would shift from alleged oversight to something far more damaging. What happened next did not unfold slowly, and it did not depend on speculation, because Massie was not building toward a rhetorical climax, but toward a documented contradiction that would collapse the defense in real time. He leaned forward slightly, not to intimidate, but to anchor the exchange in the gravity of sworn testimony, and he made it clear that this was no longer about abstract legal balancing. He stated that approximately 40 minutes earlier, after he had raised the issue publicly, the Department of Justice had quietly updated the document and unredacted Les Wexner's name. Then he held up a second copy, the revised version, and allowed the implication to settle over the room before he said the words that would define the hearing. "I caught you hiding a potential co-conspirator's name," he said, not loudly, not theatrically, but with the calm certainty of someone who has already checked the timestamps. He explained that within 40 minutes of his inquiry, the redaction had been reversed and the name had been restored to the public record. That timing was not an accident and not a coincidence, and everyone in the room understood the significance immediately. If the redaction had been legally necessary, it would not have disappeared in less than an hour. If it had been required to protect an ongoing investigation, it would not have been quietly undone the moment a congressman pointed to it. The sound in the hearing room shifted from silence to movement, the rustling of reporters typing, the mechanical hum of cameras zooming tighter, the whisper of staffers recalculating strategy in real time. Bondi's composure tightened, and she began to frame the unredaction as a correction, suggesting that if there had been an error, it would be reviewed and fixed. Massie did not let the word error stand unchallenged. An error implies accident, but what he was describing was a decision that had been implemented, defended, and only reversed when exposed. He asked directly who had made the decision to redact Les Wexner's name in the first place. The structure of the exchange changed at that point, because the question was no longer about whether a name was redacted, but about accountability inside the Department of Justice. Massie reminded the room that he had co-authored the law requiring full transparency, and that the statute did not carve out exemptions for powerful men flagged as potential co-conspirators. He emphasized that this was not a matter of protecting a minor or preserving the anonymity of a survivor. The FBI document itself had identified Wexner in a specific investigatory capacity, and that context had been obscured in the public release. The American people, he argued, had been denied information that Congress had legally mandated they receive. Bondi attempted to pivot, invoking the complexity of document review and the sheer volume of pages involved in the Epstein File release. She referenced the millions of pages processed, the time constraints imposed by Congress, and the need to protect investigative equities. But Massie's question remained narrow and relentless. Who authorized that redaction? Not why redactions sometimes happen, not how many pages were involved, but who made the call to black out a name in a document that labeled the individual as a potential co-conspirator. The exchange took on a sharper tone when Bondi shifted from procedural defense to personal attack. She suggested that Massie had remained silent during prior administrations, implying inconsistency or selective outrage. The implication was that his concern now was politically motivated rather than principled. Massie did not raise his voice in response. He simply stated that he was questioning the current Attorney General under oath, because she was the one responsible for the current release. He did not ask Merrick Garland that day because Merrick Garland was not sitting at that table. The law had been passed, the deadline had been set, and the redactions had been executed under Bondi's authority. When she escalated further, accusing him of Trump derangement syndrome and framing his inquiry as an attack on his own party, the tension moved from legal debate into raw political confrontation. It is one thing for a witness to deflect with bureaucratic language. It is another to accuse a sitting congressman of partisan pathology for asking a direct question about compliance with a statute he helped write. The attack landed in the room with an audible shift because it signaled that the defense had moved from facts to character. And when a defense turns personal, it often means the factual ground is unstable. Massie's response was surgical. He reminded Bondi that he had written the law she was obligated to follow. He clarified that his question was not about President Trump, not about party loyalty, and not about political alignment. It was about whether the Department of Justice had concealed the name of a billionaire identified by the FBI as a potential co-conspirator in one of the most significant sex trafficking investigations in modern American history. He stated that attacking him did not answer the question, and that the American people could draw their own conclusions from the refusal to provide a clear explanation. The moral weight of the room intensified because survivors were still seated behind Bondi, watching the exchange unfold. They had come not for partisan spectacle, but for transparency and accountability. The fact that the redaction had been reversed within 40 minutes of exposure made it impossible to argue that it was indispensable to victim protection. If anything, it suggested that the original concealment had been discretionary rather than legally compelled. Massie did not use the word cover-up at that moment, but the structure of his argument built toward that implication without ever stating it explicitly. Bondi attempted once more to redirect the conversation toward previous administrations, suggesting that questions about Epstein's network had not been pursued aggressively before. But Massie refused the bait. He reiterated that the present hearing concerned compliance with a law enacted by Congress and signed by the President. He asked again whether Bondi personally approved the redaction or whether someone within her department had made the decision without her knowledge. The repetition was deliberate, because in oversight hearings, repetition forces a witness to either answer or be seen clearly refusing to do so. Her refusal to identify the decision-maker became its own form of testimony. She stated that she would not sit there and be lectured by what she called a failed politician, suggesting that Massie had spent more time criticizing his own party than representing his constituents. That line crossed a boundary that most seasoned witnesses avoid, because it reframed the oversight role of Congress as illegitimate. In a hearing about transparency and redactions, the Attorney General had chosen to attack the credibility of the lawmaker asking about compliance. Massie's reaction was controlled but unmistakably pointed. He stated that he was not a failed politician, but a sitting congressman performing oversight as required by the Constitution. He reminded the room that transparency on Epstein had been demanded across party lines, and that the law did not distinguish between Republican and Democrat when it came to compliance. The attack on his character, he implied, did not erase the fact that the redaction had been reversed only after exposure. And that reversal, timed within 40 minutes, spoke louder than any accusation of partisan bias. The hearing room by then was no longer divided along predictable partisan lines. Conservative outlets began circulating the clip alongside liberal platforms because the confrontation did not fit neatly into party narratives. A Republican congressman had confronted a Republican attorney general over the concealment of a billionaire's name in a document about potential co-conspirators. The timing of the unredaction undermined any claim that the concealment had been immovable, and the refusal to identify who authorized the redaction created a vacuum that demanded further inquiry. Massie closed his segment not with theatrics, but with a question that lingered. If Les Wexner's name could be hidden and then restored within 40 minutes once challenged, what else remained concealed in the remaining pages not yet released? He noted that only 3 million of the 6 million pages required under the Transparency Act had been produced. That meant half the record was still withheld. If a redaction in the released portion could be undone so quickly, it was reasonable to ask what was embedded in the unreleased half. The power of that question did not depend on conspiracy theory or insinuation. It depended on the documented sequence of events: a redacted name flagged internally as a potential co-conspirator, a public challenge by the law's co-author, and an unredaction within 40 minutes. That timeline became evidence in itself. The argument was no longer hypothetical. It was chronological. And chronology, in oversight, is often more persuasive than rhetoric. By the time Massie's allotted minutes expired, the structure of the hearing had shifted permanently. What began as a debate over redaction volume had narrowed into a dispute over a specific decision that could not be easily justified. The attack on Massie's motives did not erase the timestamp on the revised document. The appeal to process did not negate the fact that the name had been restored only after exposure. And the refusal to name the decision-maker left a question mark hanging over the Department of Justice's internal review process. The second phase of this confrontation did not end with applause or outrage. It ended with something more unsettling. Uncertainty inside the Department of Justice about how to explain a correction that looked less like routine review and more like reactive damage control. Reporters filed stories not about partisan bickering, but about the 40-minute window between concealment and correction. Lawmakers from both parties began signaling that further oversight would follow. And in the background, the unspoken reality remained that 3 million pages were still outstanding, waiting to be examined by the same congressman who had just demonstrated that he was reading every line. What made that exchange impossible to dismiss as routine oversight was not the volume of the argument, but the alignment of incentives that should have prevented it from happening at all. Thomas Massie had no partisan advantage to gain from publicly cornering a Republican Attorney General, especially on an issue as politically radioactive as the Epstein Files. If anything, silence would have been easier, safer, and far more convenient inside his own party's coalition. Yet he chose confrontation, and that choice altered the calculus of the hearing in a way that could not be spun as predictable partisan choreography. The cameras kept rolling long after his 5 minutes expired because everyone in the room understood that the confrontation was not self-contained. Other members of the committee began referencing the 40-minute unredaction, turning what might have been an isolated exchange into a central theme. Representative Ted Lieu pressed Bondi on related issues about transparency in Epstein-linked social circles, raising questions about underage girls and political figures at private gatherings. Bondi dismissed those lines of inquiry as ridiculous and refused to entertain speculative connections. But the mood in the room had already shifted from defensive to reactive. Jamie Raskin returned to the redaction issue, pointing out that the problem was not merely that a name had been concealed, but that the concealment had been undone only after exposure. He framed the 40-minute correction as evidence that oversight was working precisely because someone was willing to read the documents rather than rely on executive assurances. The implication was not subtle. If Massie had not reviewed the unredacted files personally, that redaction might still be in place. Bondi repeated that the department had acted in good faith and that corrections happen in large document productions. But repetition does not restore confidence once chronology undermines it. The political tension inside the Republican caucus became visible in subtle ways. Some members avoided eye contact with the Attorney General, while others attempted to pivot the hearing back to familiar critiques of prior administrations. Yet the fact remained that a Republican co-author of the Transparency Act had documented a redaction inconsistent with the statute's intent. That fact complicated any effort to frame the controversy as partisan opportunism. It was no longer Democrats accusing a Republican Attorney General of concealment. It was a Republican lawmaker invoking a Republican-backed law against a Republican executive appointee. Massie did not grandstand after his exchange, and that restraint amplified the seriousness of what he had done. He did not tweet triumphantly from the hallway, nor did he seek out cameras to inflate the confrontation into personal drama. Instead, he spoke briefly with reporters about the timeline and emphasized that his goal was compliance with the statute, not political theater. He reiterated that the unredaction within 40 minutes demonstrated that the initial concealment was not legally indispensable. That calm framing made it more difficult for Bondi's allies to portray him as reckless or vindictive. Meanwhile, Bondi's staff faced a different problem inside the Department of Justice. The question was no longer whether the redaction existed, but how it had been approved in the first place. In high-profile document releases, redaction decisions typically move through layers of review, especially when they concern individuals of significant public prominence. If Wexner's name had been blacked out in a document identifying potential co-conspirators, someone had made a judgment call that the context warranted concealment. The 40-minute reversal suggested that the judgment call was not anchored in an unmovable legal constraint, but in discretionary caution that evaporated under scrutiny. That distinction matters because in the Epstein case, public trust has been fragile from the beginning. The investigation involved wealthy, well-connected individuals whose relationships with Epstein were scrutinized for years. The Transparency Act was passed precisely to address suspicions that powerful figures might be shielded through selective disclosure. When a redaction in a co-conspirator context disappears only after a lawmaker points to it, the suspicion that the act was designed to dispel reemerges in sharper form. It is not the redaction alone that damages credibility, but the timing of its reversal. Bondi's decision to attack Massie personally compounded the problem rather than containing it. Calling a sitting congressman a failed politician during sworn testimony does not strengthen a defense built on process and legality. It shifts the frame from compliance to confrontation, from documentation to personality. In a room filled with survivors of exploitation, that shift can appear tone-deaf, because the underlying issue is not partisan loyalty but transparency in a case that traumatized dozens of people. The optics of attacking the questioner instead of answering the question linger long after the gavel falls. The media response reflected that shift. Conservative commentators who might normally defend the Attorney General hesitated because the confrontation was initiated by one of their own. Liberal outlets highlighted the 40-minute unredaction as evidence of reactive transparency rather than proactive compliance. Cable news segments replayed the moment Massie held up the revised document and stated, without theatrics, that he had caught the department hiding a name. The phrase traveled quickly, not because it was inflammatory, but because it was anchored in a timestamp that could be verified. Inside the Judiciary Committee, murmurs of inherent contempt began to surface more openly. The Transparency Act did not exist as a symbolic gesture. It carried enforceable expectations. If the Department of Justice continued to release only half of the mandated 6 million pages, and if redactions appeared to protect powerful individuals rather than vulnerable victims, Congress possessed tools to compel compliance. Inherent contempt is rarely used in modern times, but its existence serves as a reminder that oversight authority is not merely rhetorical. The mere discussion of it signaled that Massie and Ro Khanna were prepared to escalate beyond hearings if necessary. The broader political implication extended beyond Les Wexner's name. The confrontation exposed a tension between institutional loyalty and statutory obligation. A Republican Attorney General defending her department faced a Republican lawmaker invoking the text of a bipartisan law. Party alignment did not dissolve constitutional roles. Congress writes laws and oversees their execution. The executive branch enforces them. When those roles collide inside the same party, the friction can be sharper because the expectation of unity collides with the duty of oversight. Massie's libertarian reputation added another layer to the moment. He has long positioned himself as skeptical of executive overreach, regardless of which party occupies the White House. That consistency insulated him from easy accusations of selective outrage. By grounding his argument in the statute's language rather than partisan rhetoric, he reinforced the idea that this was about structural accountability. The fact that he had personally reviewed the unredacted files undercut any claim that he was relying on secondary interpretations. He had seen both versions with his own eyes. Bondi's allies attempted to reframe the narrative by emphasizing that Wexner had not been charged and that appearing in investigative materials does not equate to criminal guilt. That point is legally accurate, but it does not address the redaction question. The issue was not whether Wexner was guilty, but whether the public was entitled under the Transparency Act to see that the FBI had internally identified him in a potential co-conspirator context. The distinction between accusation and conviction does not nullify Congress's mandate for disclosure. Transparency does not presume guilt, it exposes process. As the hearing wound down, the unresolved question remained stark. Who made the decision to redact that name? Bondi had not provided a clear answer, and that silence became a focal point in subsequent commentary. Oversight hearings often hinge less on dramatic admissions and more on conspicuous omissions. A witness who refuses to answer a narrow question invites deeper investigation. The absence of a clear chain of authorization inside the Department of Justice opened the door to subpoenas, depositions, and internal communications requests that might illuminate the redaction process more fully. The survivors seated behind the witness table did not cheer or shout. Their presence remained quiet but powerful, a reminder that this confrontation was rooted in a case involving exploitation and abuse, not abstract politics. The debate over redactions was not academic. It concerned whether the public would see the full network of associations and investigatory findings tied to Epstein's crimes. When powerful names are obscured while victims' details surface, the imbalance feels personal to those who endured harm. That moral imbalance hung over the hearing long after microphones were turned off. By the end of the third phase of this unfolding story, the confrontation had transcended the specifics of one document. It had become a test of whether the Transparency Act would function as written or be diluted through discretionary interpretation. It had exposed the fragility of public trust in high-profile investigations involving wealth and influence. And it had demonstrated that oversight, when executed with documentation rather than outrage, can force immediate correction. The question that now hovered over Washington was not whether the redaction had been undone, but what else might be corrected only if someone was willing to look closely enough to notice. The final and most consequential layer of this story is not the exchange itself, but what it signals about the remaining half of the record that has yet to see daylight. 3 million pages have been released under the Epstein Files Transparency Act, and 3 million pages remain outstanding, suspended somewhere between statutory obligation and executive discretion. That numerical split alone creates a structural imbalance, because the public cannot evaluate transparency in fragments. When a single redaction in the released portion collapses under scrutiny within 40 minutes, it forces an uncomfortable question about what remains hidden in the portion not yet delivered. Massie understood that from the beginning, which is why his confrontation did not end with the unredaction of Les Wexner's name. He framed the moment as proof of concept, demonstrating that oversight is not ceremonial when backed by documentation and persistence. If one name flagged internally as a potential co-conspirator could be concealed and then restored once exposed, the logical extension is that other discretionary decisions may exist in the unreleased tranche. That is not speculation. It is a conclusion drawn from observable behavior. The department corrected what it had initially defended, and that correction altered the credibility of every remaining redaction. The discussion of inherent contempt that followed was not theatrical escalation, but a reminder of constitutional balance. Congress passed the Transparency Act, and the executive branch is bound to execute it faithfully. If compliance appears partial or selectively interpreted, Congress retains enforcement mechanisms that are rarely used precisely because their invocation signals institutional breakdown. The possibility of fines or other penalties for non-compliance is not about punishing personalities, but about preserving legislative authority. The confrontation between Massie and Pam Bondi illuminated that tension in a way that polite negotiation could not. Inside the Department of Justice, the 40-minute timeline became an internal liability as much as a public relations problem. Redaction protocols in sensitive investigations are supposed to be deliberate, layered, and defensible. When a redaction can be reversed within less than an hour after exposure, it suggests that the legal necessity for concealment was not ironclad. That does not automatically prove malicious intent, but it undermines the claim that the initial decision was immovable. Institutional credibility depends on consistency, and rapid reversal erodes the narrative of procedural inevitability. For Bondi personally, the hearing left a mark that extended beyond that single day. An Attorney General's authority depends in part on the perception of impartial stewardship over politically explosive matters. When she chose to attack a sitting congressman as a failed politician rather than identify who authorized a redaction, the exchange shifted from compliance to confrontation. In oversight settings, the refusal to answer a narrow question often becomes more memorable than any prepared defense. The phrase Massie used, that he caught the department red-handed, gained traction not because it was inflammatory, but because the timeline gave it weight. The broader political environment amplified the stakes. The Epstein case has long symbolized the intersection of wealth, influence, and exploitation, a combination that breeds suspicion about institutional protection for elites. The Transparency Act was designed to counteract that suspicion by mandating disclosure without favor. When a billionaire's name identified internally as a potential co-conspirator appears redacted in the public version, it touches directly on that symbolic fault line. The unredaction within 40 minutes may have corrected the document, but it did not erase the impression that concealment had been attempted. Massie's position within his party complicates any attempt to dismiss the confrontation as partisan maneuvering. He is not known for reflexive loyalty to executive authority, regardless of which party controls it. His libertarian-leaning skepticism toward centralized power has often placed him at odds with both Republican and Democratic leadership. That reputation lent credibility to his claim that the issue was statutory compliance rather than political sabotage. When oversight is exercised by someone perceived as independent, the accusation of partisan motive loses force. The unanswered question about internal decision-making remains central. Who decided that Wexner's name should be blacked out in that specific context? Was it a mid-level reviewer exercising excessive caution, or a directive influenced by concern about reputational consequences for a powerful figure? Bondi did not clarify, and that ambiguity invites further inquiry. Subpoenas for internal communications, review memos, and authorization chains could illuminate whether the redaction was an isolated misjudgment or part of a broader pattern of discretionary shielding. Public trust in high-profile investigations is cumulative rather than episodic. Each unexplained redaction, each reversal, each deflection contributes to a broader narrative about whether justice operates evenly. The Epstein Files carry unique weight because of the network of associations surrounding his crimes. Transparency in such cases is not merely about satisfying curiosity. It is about demonstrating that wealth and influence do not distort accountability. The confrontation on February 11th became a microcosm of that larger test. The survivors who watched the hearing may not measure success in legalistic terms, but they understand instinctively when institutions appear evasive. For them, the debate over redactions is inseparable from the history of how Epstein's network operated for years without interruption. When a law promising full disclosure produces selective concealment, it feels like a continuation of that imbalance. The rapid correction within 40 minutes may have validated oversight, but it also confirmed that vigilance is necessary. Transparency was not automatic. It had to be forced. The final layer of this story is not about a single billionaire's name, but about whether the remaining 3 million pages will be subjected to the same scrutiny. Massie signaled clearly that he intends to review every line, and his colleagues from both parties have echoed the call for full compliance. The Department of Justice now operates under intensified observation, aware that discretionary decisions may be challenged in real time. The episode has raised the threshold for trust, meaning that future releases will be examined with heightened skepticism. In the end, the confrontation did not produce a dramatic confession or an immediate resignation. It produced something more durable, a documented example of oversight compelling correction. The phrase, "I caught you red-handed," resonates because it was tethered to evidence, not exaggeration. 40 minutes separated concealment from correction, and that gap will be cited in every subsequent debate about compliance with the Transparency Act. The story does not end with that hearing. It begins there. As the political system absorbs the implications, one fact remains indisputable. A Republican congressman who co-authored a transparency law confronted a Republican Attorney General about a redaction shielding a powerful name in a co-conspirator context, and within 40 minutes, the redaction disappeared. That sequence cannot be erased, reframed, or minimized without rewriting the timeline itself. The remaining pages, the potential contempt proceedings, and the unanswered questions about internal authorization now form the next chapter. The stakes extend beyond party loyalty or personal reputation. They concern whether legislative mandates will be executed faithfully when powerful interests are implicated. They concern whether oversight will be treated as legitimate inquiry or dismissed as partisan hostility. And they concern whether the promise embedded in the Epstein Files Transparency Act will be fulfilled in substance rather than appearance. The hearing on February 11th demonstrated that transparency can be enforced when someone is willing to demand it. But it also revealed how fragile that enforcement can be without constant scrutiny.